Welcome to Two Taps and Friends. Grab your favorite drink, get comfy, and let's dive into another episode of Two Taps and Friends.
Welcome back to Two Taps and Friends. I'm your host, Danny Rosenberg, and today I have a very special guest, good friend of mine, colleague for a long time, attorney Michael Wild. Michael Wild is, first of all, welcome, Michael.
Thanks, great to be here.
Michael Wild is the managing partner and owner of WFP Law. And this is what he does and what everybody knows he does if you know him. And if you ask me, he's the biggest name in the industry because you see him everywhere. Everybody knows the guy. Their firm does estate planning, asset protection, and probate. We'll break that down to the laymen that aren't lawyers, and we'll get into that kind of stuff. But Mike, welcome.
Thanks. Long time, first time.
Long time, first time, right? But how long? Let's first of all give an intro. Let the viewers know how long you've been doing this, how you got into this, and a little bit about yourself, if you don't mind.
Sure, absolutely. So my firm was started 16 years ago. I graduated law school from University of Florida, and I knew I wanted to do estate planning. I knew I wanted to open my own firm, but I knew I needed to learn the business of law first. A lot of good lawyers out there that make no money.
Oh, yeah.
So I joined a small firm that did real estate, and that was in 2006. And what happened after that? Turned into foreclosure. So I was in court all the time, even though I knew I wanted to do transactional. But I learned a lot about how to run a small firm. 3 years after that, my start of my law career, I went to my boss for my review, and I said, I'm putting in my notice, I'm going to start my own firm. And they said, oh, doing real estate? I said, no, estate planning. They said, well, you never done estate planning in your life. It's hard to get clients. What are you doing? And I said, I never have any fear about getting clients. Revenue generation is not the worry. So started the firm in 2009. And built it to now. We have grown exponentially. We have a team of 5. I am the owner, and then we've got 4 either non-equity partners or associates, depending on their level. And we all do just estate planning, asset protection, and probate administration.
Wow. And dude, I think it's interesting when I talk to people like myself or you or people that own firms. It's like we knew we were going to own a firm very quickly,
Absolutely.
right? Like I went and I was like, when I was a public defender to learn how to try cases, but I know I was just putting in my time. And if you know how to run a business, you know how to run a business. Or if you have there's a certain wiring, right? It's a gene.
Absolutely.
That's why people are like, Danny, when you get another person that's like-minded like you, it's hard to kind of like round them in, right? Because they want to go do their own thing,
Yeah,
So
and they don't get it.
We're hybrids, especially like the attorneys that can actually make money. Like, attorney, like the law is averting risk, really. That's what lawyers are trained to do. Entrepreneurship is literally the opposite, right? You're all about risk. But I think it's super interesting that you just decided wills and, trusts. Like, first of all, let's break down wills and trusts. So for the layman, wills, and we're going to break it down more, but this is, you've heard what a will is, you've heard what a trust is, how to leave things for your children, how to leave things for family members, but we'll get into that each. But like, why this field? Did you have some background or you just knew something? Where did it come from?
I had a great professor in law school, Doug Miller. And I still remember the first day of class says, what is estate planning? Everyone's raising their hand, giving legal definitions. He goes, no, it's what happens to your shit when you die. and he starts telling these stories. And I still remember to this day why we have a simultaneous death rule in the state of Florida, where this married couple with no kids, they're driving, they get hit by a train, right? So the parents of the husband and the parents of the wife are fighting in court over whom inherited from whom. So one eyewitness says the husband's head came off. He was decapitated and blood was squirting in the air. What did that mean? His heart was still beating. He inherits. His parents get it. I'm like,
wow.
That's crazy.
Right.
So I found that so interesting. And then after that class, and even that final exam was a guy trying to hide his assets from his wife in preparation for divorce. I was like, this guy is so cool. So we went then.
Some people would not say that's cool, but yeah.
So we went then to the next class was Intro to Income Tax, which on paper sounds so boring.
Oh.
But it wasn't learning the tax code. It was learning how to beat the tax code.
Right.
Where do we get around it? How do we get, which is why the CPA I use is hangs me over the line, and I like it.
Right.
So the creativity was what drew me to estate planning and asset protection. But I always thought I was going to be a litigator. When I was in law school, trial team and the mock trials, they give you all the crap stuff, the research and the writing. I mean, you don't have to do any of that.
Right.
All you do is you go in court, you do the cross-examination, you do the closing argument. And I remember one time I was doing a closing argument for a case, and one of the jurors, who they're all other law students, was crying. I was like, oh, I'm pretty good at speaking.
Right.
But then when I figured out that litigation is really just knowing the opposing counsel, throwing the same frickin' pleadings back and forth over and over and over, I found litigation to be boring. It's none of that Alan Shore,
I beg
Danny
your
Crane.
pardon, sir.
Yeah, I know.
I'm messing around.
You're
I'm
good at
messing
it,
around.
though.
I guess
But-
you could say, I've never heard anyone say that, but
Yeah.
listen, you're Michael Wild. You say wild things.
I say wild things.
But I get it.
Yeah, I just found that it was so redundant. It was like I would go to court and I'd be like somebody would come in that was not in the same, not been in front of the same judge I had, and they would think they had found this smoking gun case. I'd be like, yeah, Judge, shepherdized that. That's been overturned. And then that'd be it. And I would just Michael Jordan shrug and be like, yeah, I'm done.
Right.
But what I do now is I prevent that litigation. Like I make sure that my clients are tied up in a way where they're completely protected so that if something does go wrong, then they can look at the other side and say, look, good luck. Like take the insurance, but that's all you're going to get.
Right.
Because everything else is already protected. So from a litigation avoidance standpoint, or sometimes if the clients already have a judgment against them, it's about leveraging and trying to settle that claim. I find that so much more interesting than, okay, something already happened and now we have to settle it.
Yeah, I mean, you're fine. That's the thing is like we're a litigation firm, and when we have people come in and they have something, if it's airtight, we're
Yeah.
going to tell you, listen, you're going to spend a lot of money here, and we could talk.
Yeah.
But the law is a law that comes down to it. You get a smart jury or a smart judge, and they see something's airtight, you're spinning in circles. So it is, obviously, I always recommend to people to have somebody. That's why I send all my people to you.
No, I appreciate it.
I use you,
Yeah,
right?
it's true.
But let's talk about, and we'll get into some of all these things, but let's talk about wills. Like, talk to me about some of the things that you see, like the most common like misconceptions that when a layman comes in and they think, something they may have learned in TV shows or in the movies, right? Tell me like what you see as a misconception. What's a big thing you want to put out there to viewers?
Number one thing across the board, I love it. People think wills avoid probate. Wills do not avoid probate.
Well, let's explain probate. Why don't we start there?
sure.
Intestate, probate, because people don't know that, right?
So assets that are in your own name with no beneficiary designation, when you die, have to go through a process called probate,
Right.
which is really the cleaning of the assets. So what happens is first we have to figure out who's entitled to manage your estate. That would be the personal representative.
Right.
Sometimes that's through a will. Sometimes, like you said, intestate, who has the right to do it. There could be a competition over that. But then that person has a job. They have to find the assets. They have to secure the assets. They have to create an accounting. They have to pay off creditors and taxes and all these debts, pay the court, pay the attorneys. All these things have to be done. The process usually takes, on an easy side, about 6 to 8 months. On a long side, 18 to 24 months.
Yeah, it sounds like a nightmare. How do you find things of people like if they're not documenting or telling other people?
Well, and we sometimes have to use private investigators.
Wow.
Because that's the thing. Somebody dies. The biggest question I get is, I didn't know what mom or dad had. And so we have to find those assets first. And then depending on the type of asset, if we're dealing with, okay, you died and the only thing you left was your homestead, let's say. Okay, it's not the end of the world, right? Homestead is protected from creditors. In Florida, they account for homestead being valued at 0 for probate purposes. So it'll cost you like $5,000, take, probably 2 months. That's no problem. But when you have things that are like a business, for instance, you die, you own a business or rental property or investments in other people's businesses, those things, not only do they take a long time to value and probate, but they die on the vine. You have a rental property, right, in your name. Let's say it's not in an LLC, it's not in a trust, it's just in your name. You die. Even your wife trying to get that property, she's not entitled to collect rent. She's not entitled to fix the plumbing. She doesn't own it.
Right.
She has to become the personal representative, get the letter of administration, step into your shoes just to be allowed to secure the property. Then you know what happens a lot is the renter says, screw you, I told your husband I'd pay him. I didn't tell you I'd pay you.
Wow.
So I'm not going to give you rent. Well, now she's got to go through the eviction process. And that could take months after the probate's done. So this is something that entire time, property taxes, insurance, overhead has to be paid. So now it's actually not an asset, it's a liability.
Right.
All because it wasn't secured in the right way. And so that's why every single client I have, and we're talking about 500 clients a year times the last 15 years, has a revocable trust. at least a basic revocable trust. Some people need tax planning, some people need asset protection planning, but everyone needs a trust. Because what we were talking about, the probate process, that happens whether you have a will or not. So the will, the only thing the will does, different from intestate, which intestate means that you died without any documents.
Right.
The only difference is, with the will, you're appointing who's in charge. So you might say, you know what, I love my wife, but I think my son should be in charge. He knows more about the assets. So
That's a lovely conversation.
I know, right?
That might be a quick way to death.
That is a quick way to death. and with your wife, it would not count. She's very astute.
Yeah, dude,
but
never fly.
yeah,
Go ahead, right?
but sometimes they say, or like let's say you have 3 kids, and you say, well, you know what, my middle child is a CPA. I want them to be in charge,
Right.
even though they're not the others. So you choose who you want to be in charge. That's fine. And if you have minor children, it appoints a guardian for those children and says who I want to raise my children. But that's it. It determines beneficiaries, but all those beneficiaries have to wait through the probate process. So it costs a lot of money, usually between 3 and 10% of the estate value. There could be major creditors. There could be litigation, because a will is public record. So a will gets published, and then somebody comes out of the woodwork and says, no, Danny was my dad too. And then all of a sudden, there's the litigation.
Right.
And we have to fix that. And I know you and I both have a lot of common NFL colleagues.
Right.
That's a very common issue.
Very common issue.
And so what we have to do is we have to be very clear in the documents who's allowed to inherit and who's not.
Right.
But when it's through the will, it's a free-for-all. Everyone has a right to litigate. When it's through a trust is a private document that cannot be contested.
So it's not nearly, it's airtight. I mean, nobody can
Yeah.
even see it, really. You can't get into
Exactly.
it. They have no idea about it. And if they come in and say, this guy's my daddy, well, there's a trust. You're not in there. Sorry.
Correct. And in
Right?
fact, a lot of times I'll put in there that if they do have an illegitimate child, I'll write in they're specifically disinherited, which, I know it sounds harsh, but you have to be clear. Law is all about getting rid of ambiguity.
Right.
And if they don't, but they think they might, I'll say, these are my only children. Any other child that claims to be mine is specifically disinherited, so it doesn't even have to be someone they know about. That sometimes happens, especially with professional athletes, but also I have a lot of musicians that are clients, and they have those type of concerns as well. I had one musician, a rapper, it was very public, and he died, and his mom called me immediately because TMZ got a hold of the will. And she was like, oh no, they have all the information. I said, they have no information. The will says nothing. The will says, my mom's the personal representative, I have a trust.
So he had a trust anyway. It didn't matter.
Oh,
He
yeah.
was your client.
Correct.
So he just did a will with you, or did you do both?
Well, we do
sometimes?
both.
Right.
So the will is important from a standpoint of we do want to have a safety net. So let's say we do a trust. A trust is like an LLC or even like a safe. Let's say you have a safe at home, and it's a burglar-proof, fireproof, waterproof safe.
Right.
But you leave all your watches on the dresser. That didn't help you.
Right.
We still have to get the watches into the safe.
Right.
If you do that during life, it's very easy. It's called funding the trust.
Right.
But if you forget, and most of the time, the longer you go, like for instance, we did your plan a while ago. You and I are both young guys.
Right.
So hopefully neither one of us is going to die anytime soon. But let's say many years in the future, you opened a new bank account or you bought a new condo or something like that, and there's just 1 or 2 assets sitting outside of the trust. Those still have to go through probate. But the only beneficiary of the will is the trust. So it still can't be contested.
Right.
So there's still a lot of benefit to it. But we use that will, it's called a pour-over will, to make sure that we eventually get all assets into the trust.
Right. Get it. So the trust is where people want to be, right?
Absolutely.
So I mean, the old misconceptions. So when you see people come in and just say, they just have no clue, right? They think, I have a will, it's airtight.
I'm done.
I wrote it on my pillowcase.
Yeah.
And I shoved it in the drawer, and I'm good, right?
Yeah, yeah.
Or I wrote another one, and plus, how easily can these things be just forged? Like, are they
correct.
notarized? I mean, obviously, they have to be witnessed. Tell
Yeah.
us the rule about, just a quick, what's
No,
the rule
sure.
on wills in
So
Florida at least?
Yeah, wills in Florida, they have to be, they can't be handwritten wills. That's called a holographic will, where you write on a napkin like.
We don't take that,
Yeah,
right?
we don't take that. I give Danny
Some
my
states
car.
still take that?
Some states do. Some
Okay.
states do take that. Florida does not. You have to have 2 witnesses and a separate notary. So it's different from real estate. Not that anyone out there, unless you're a real estate attorney, you probably don't care about this. But in real estate, what the notary's doing is witnessing the guy buying the property, right?
Right.
So, or selling the property.
Right.
The witness can be the notary also. For a will signing, the notary is actually notarizing the witnesses. So the witnesses on one page, that's why it's very important, this is called something called a self-proving affidavit.
Right.
On one page, the person signing the will signs it, and the two witnesses say, we saw him sign it. On the second page, the two witnesses sign, and the notary says, I saw the witnesses witness the guy sign it.
I saw, you
Yeah.
you know, I know that you know.
Exactly. And if you don't have that, what happens is, and it's so depending on when the person dies, it could be a big problem.
Right.
You have to verify the will in court by having the witnesses testify. Well, if you signed your will in 2005 and you die in 2050, they might be dead too.
Right.
So it's very important to have that self-proving affidavit. So the execution of the will is important, which is why also it's so funny when I see these ads for like willandtrust.com or LegalZoom, do it yourself. It's insane because
how are they doing that? You go online, they just instruct you to do this, and you do the best you can do with it?
It makes no sense to me because the thing about it is even if you were lucky enough to get something simple like a power of attorney right? Maybe you execute it wrong. So, or I've seen this happen all the time.
This is invalid.
The power of attorney, I've seen it all the time. So there are parts to initial and parts to sign.
Right.
Well, we'll get it, and none of the initialed parts are initialed. And that's very important for certain tasks. So all of a sudden, someone comes in, they go, oh, I have my mom's power of attorney. I need to change the deed. And it doesn't allow you to do that. Yeah, it's not in there. Or it's not witnessed. And so, well, we can't use it. The bank's not going to take it. Or it's a springing power of attorney, which doesn't even exist in Florida anymore, where you have to prove incapacity because the banks don't want that liability.
Oh, what a nightmare.
So all these things, how would you know? Like, how would you know if your son needs a special needs trust? Or how would you know, like, what the different protections a trust can give as far as dynasty protections, as far as, like, what I want to put in to restrict my kids or protect my kids? Outright distributions are awful. Nobody should have those. But you don't know if you don't speak to an attorney. So what they do is they say, oh, well, you could try drafting it yourself. And then if you have questions, then you call an attorney. And then what they do is they refer to someone who charges you to do it. Instead of trying to operate on yourself, just go to an attorney initially and find out what your options are. It makes no sense. I mean, I always tell people, I go with an attorney that you feel comfortable with. It does not have to be me, but it does have to be someone who specializes in estate planning. Right. Not a personal injury attorney that dabbles in it, not a real estate attorney that says, oh, yeah, I can make a will for you, because they don't know what they don't know. Just like I don't do deeds.
Right.
Deeds seem simple. You mess up a property description, you're done. You violate the homestead exemption.
Right.
So we don't mess with anything that's not estate planning, asset protection, or probate. And I always urge clients, don't do it yourself, because by the time we figure out you did it wrong, you'll be dead.
Exactly.
Yeah.
That's the thing is, like, I lost my mom, which was terrible the last couple of years, and you have to deal with things like this, right?
Yeah.
I mean, thank God my father's still around, and a lot of it was simple, but
Yeah.
You realize, like, when I go, like, kids are going to be scrambling. Nobody knows anything. Nobody knows how to do anything. Nobody knows how to distribute things. And, like, people in life are scared to have these conversations. Like, one of the worst days I can think of was sitting with you in that office.
Yeah.
There. Not that I don't love you, but I'm sitting near my wife. We're talking about all the assets. I'm sweating. I'm nervous. I'm like, oh, you feel like you don't have enough assets and you have too many assets. You had it in the wrong places. Then you're going to have these conversations. Like, we set up a trust, right? We're going to talk about trust now, right? That's a good transition. We really haven't transitioned. We've been talking about them the whole time. We talked about, well, who's going to be the beneficiary? If you guys die before your kids are of age, who's going to take the kids? And that started some drama, right? I'm like, well, my family. Well, I don't know. Your parents are older. What about my brother? And right, it started all of this, like, it's uncomfortable stuff that has to be had. You know what I mean?
Oh, yeah.
So that's why I always tell people, listen, just go sit with Mike. And you make it easy. I mean, the way you're talking now, because that's how he talks when you talk to him. It's just like having an everyday conversation. You're not sitting there with some snug old dude that's like, just speaks to you in tongues, right?
Yeah.
So the trust, that's complicated, though. There's so many moving parts in a trust, right?
Yeah.
Like, for instance, if you have properties in different states, you got to move those properties into the trust.
Sure.
Every time you open a new bank account, you have to move it in trust. Talk to me about how trust operates, because I have an understanding of it, but give a quick synopsis.
Sure, absolutely. So the trust is a contract. It's a contract between the grantor, yourself, the trustee, which is also yourself initially, and the beneficiary, which again is you. So all three parts are played by you to begin with, which is why we call it a disregarded entity while you're alive. You don't change the way you pay your tax returns. It doesn't restrict you. It doesn't offer any asset protection on its own, but it does allow you to know that if something happens to you, death or incapacity, your family's protected.
Right.
Now, the trust itself is going to list the next level of trustee and the next level of beneficiary, most likely, in your case, spouse in both situations.
Right.
So we don't restrict a surviving spouse either.
Right.
We do protect a surviving spouse, though, because the trust, once it becomes irrevocable, gives complete protection to that spouse from any debts you leave behind. So those debts die with you, she gets the money. When both of you pass is where we really, the rubber hits the road as far as the real
Right.
protections and restrictions in place. And this is where trusts get a little nuanced. So for my trust, and yours, is our kids, because my kids are 16 and 11 now. In fact, my daughter just got her license yesterday.
Oh, God.
So 16 and 11 now. And I have listed in my trust that until they are age 30, they have to ask permission to use any of the money that's not for basic needs, health, education, maintenance, and support. So until they're age 30, my dad is listed as the backup trustee, so they say, Grandpa, can I have this car? Grandpa, can I invest in this business? Can I have money for a wedding? And then my father, as the trustee, decides if that's a good decision or a bad decision. When they turn 30, they don't get a distribution. What happens is they get the right to become the trustee. So it's like changing the president out of the LLC or the company. And what's great about that is, while they no longer are restricted, they're still completely protected from divorce, creditors, litigation, bankruptcy. They might marry the wrong person. It doesn't matter. It's better than a prenup.
Right.
Now, we can even go further than that. I just have an age restriction in mind. But I've had people put in things like you have to take a drug test if their kid has drug problems. I've had where you have to have a job, so they have to show their W-2 or 1099 income or a college degree. I've had people where you have to
take over in that role. You're saying.
in that role. Yeah, so they don't
like a
necessarily,
job interview almost.
Exactly.
Right.
So they don't get disinherited, but they have to prove things. Now, I've had things that are as strict. I had one guy, it was hysterical. He said, in order to be trustee, my kids have to read the Constitution and understand how liberals are ruining the nation.
Oh.
I said, I can enforce
That's
the
a
reading.
little subjective,
I
right?
did. I said, I can enforce the first part, not the second part. But realistically, as long as it's not against, the law, as long as it's not like, hey, you have to kill someone,
They can do anything.
They can do anything. So I've had a very popular one is you can only receive as much money from the trust as you earn in that year. So a lot of my clients are very wealthy, and they don't want their kids to want to do nothing. They want them to want for nothing, but they don't want them to want to do nothing.
Right.
So what they'll do is they'll say, okay, if you made $400,000 last year, you could take up to $400,000 without even the trustee's permission. If you made $50,000, you take $50,000. The great thing about that, what I like about that clause is if you're making $5 million a year, you're not going to take anything from the trust. You're going to leave it there for your kids.
Right.
It's already protected. It's not going to be taxed again. So it's,
But what about it? Like if you're struggling,
then you can take.
But you could take what? You didn't make any money.
Well, no, with trustee permission. So at that point,
with permission.
yeah. So at that point,
Right.
you go to the trustee and you say, hey, listen, I need a little bit. I had one guy, it's funny, he was a beneficiary of a trust like that, but he was in his 60s. He's a yacht broker. He made all his money in January and February and then partied the rest of the year. That was it. He was like, I double it from the trust. I made 200 grand. Give me 200 grand from the trust. That's it. I'm good for the year.
Smart play.
Yeah.
Smart play. So yeah, I mean, trust is what it's a revocable, irrevocable. Talk about that.
So irrevocable trusts are only used in asset protection and tax protection purposes, or Medicaid, if you're doing Medicaid for older people. But everyone needs a revocable trust, and some people still need irrevocable. I have an irrevocable trust. I use it for asset protection purposes. Because I'm divorced, I don't have marital protection like you guys have. So marital assets are shielded in Florida from individual creditors. Someone sues you, they can't take your joint assets. But for me, I needed a second wife without having a second wife. So what I did was I created an irrevocable trust for the benefit of my children. My ex-wife is the trustee of that. I have no control over that trust. That trust owns a portion of an LLC that my revocable trust owns another portion of, and that parent company is then the owner of many subsidiaries underneath it.
Wow.
This is basically a limited partnership.
Right.
And so I created that by using an irrevocable trust. So with limited partnerships, I always like to use irrevocable trusts rather than people, because I could have used my brother. I could have said, okay, my brother, but then my brother is a partner and I have to give him the money.
Right.
With an irrevocable trust, I'm giving it to a trust for my kids for later in life. So it's a little bit better. So irrevocable trusts are used for that. Irrevocable trusts are used for gifting. So spousal lifetime access trusts are a type of irrevocable trust where if your estate is over the exemption amount, which right now is the highest it's ever been at $14 million. But it's going to, I mean, Trump won't always be in office, and it'll eventually, the Democrats will lower it again. Biden wanted
So
to
to
be only
explain
$3
that,
million.
sorry, but up to $14
Oh, yeah.
million can be given. Explain that a little bit.
So the estate tax exemption is what the amount that you're allowed to pass to anyone that's not a spouse, because spouses, it's unlimited,
Right.
without any tax. And anything above that, there's a tax, and it changes year to year. Right now, the exemption is very high. In fact, next year it goes to 15. He's already, with the new tax bill that was just passed. So we'll take $15 million per spouse tax-free. So your family, your kids can inherit, if you both died this year, next year, $30 million
Without being
tax-free,
touched.
without being touched.
So estate tax is essentially, unless you're in, essentially, you're in big numbers, you're avoiding it.
Currently, yeah. And so right now, it's the highest it's ever been.
Right.
And not just that, it's what we call unified, which it's never been unified before the Trump tax plan of 8 years ago, where you can gift that much too. So let's say you had $40 million right now, and you said, whoa, while the getting's good, I'm going to give away $30 million to my kids in an irrevocable trust or whatever it might be, and that's out of my estate now. So then I'm grandfathered in. When the exemption drops back down, I've already used as much as I possibly could. And if it keeps going up, you gift more. So we have a unified exemption. Before it used to be, even in 2010, which everyone points out there was no estate tax, there was also only a $1 million gift tax exemption. So
I remember that.
Yeah, so when Steinbrenner died, or I would say faked his death,
Yeah.
the Yankees went estate tax-free to the kids. But if he wanted to gift them the Yankees that year, he still would only be able to gift $1 million worth of value.
Worth of value, wow.
This year, it's big. So the biggest thing about that this year is people that are on the cusp. If you're over 15, under 30, like that window, you have to take advantage of this tax plan. It's the most advantageous we've ever had, especially if you own a business, because businesses can be discounted. If you create a limited partnership, like I was talking about, and you gift non-voting interest of that limited partnership, there's a discount already because you're gifting interest that isn't controllable. Like the kids' trust doesn't really have any voting rights. They can't sell it. It's unmarketable. So it's worth like 60 cents on the dollar. If you have your own business and it's hard to value, you get even additional discounts on that. So I've had clients that their net worth is like 60 million and we still make them tax-free. And
Wow.
even beyond that, if a client's worth $2 billion, we can still sell shares, at a discount. So there's a lot of things we can do, but only under this tax plan. Because if the Build Back Better plan would have passed a couple years ago, when Joe Manchin, thank goodness, voted no on it, otherwise it would have passed, all of this would have gone away. So when clients tell me, we're fine, we don't have to worry about it anymore, I'm like, for now,
Right. It could all change.
Yeah,
Drop
we
of
have
dime.
a longer runway is what we have. We
Right.
still have to do it. We just have a longer runway with Trump in office.
Now, what about that with trust? I mean, we're talking big numbers, millions and billions. You recommend everybody should have a trust, whether you're worth a bunch of money or not. Explain that, a little bit, just to kind of like for a person listening, it's also disheartening when people are listening billions and billions because this is not the conversation.
No, of course.
Right?
Yeah. No, it's so funny because a lot of financial advisors, they'll say to me, my client's not a millionaire, so he doesn't need a trust. And I'll say,
Financial advisors, first of all, they drive me nuts.
Yeah.
No knock, I have a lot of friends, but if you have a conversation with a financial
Yeah.
advisor, they're always like, oh, you need this, you're not going to be able to retire. Listen, I'm like, how much money do you make?
I know.
I feel like you're never making enough money for the financial advisor,
goalpost keeps
who half the
moving.
time you're making more money than. It's the funniest thing. But,
yeah.
We'll have a bunch of financial advisors on here. I'm sure they're going to be pissed I said that, but you know what I'm saying. But
100%.
go ahead. What were you saying?
Well,
Sorry,
and there are a lot of astute ones out there, but some of the
lot of
novice
astute
ones,
ones,
some of the novice ones, they'll say, oh, my client is only worth $2 million. He's not taxable. He doesn't need a trust. I'm like, the trust has nothing to do with the estate tax.
Right.
Like, that's when we talk about the irrevocable trust and the limited partnerships. For a revocable trust, the threshold is $75,000. I always tell someone, if you have less than $75,000, you do not need my help.
Right.
So when
but 75,000 worth, right?
Yeah, total net worth.
Not cash,
Total,
right?
total net worth.
Right.
Because here's the thing. So if you have, there are certain situations where, let's say you just have, let's say a modest amount. Let's say you have $1 million, because $1 million net worth. So, okay, you say, well, I'm not really worried. My $1 million, it's my house and it's a bank account or a brokerage account. Say, okay, well, tell me a little about your family. Okay, well, I have one son and he's on disability. I'm like, whoa, if you give that to your son, he's cut off a disability. So maybe what we need to do is we need to put it in a trust so that way he can still retain his disability payments, but still get the inheritance.
Right.
Or how about, I've got a $2 million net worth. I want to give it all to my daughter, but I hate the guy she's married to. Okay, well, as soon as you give it to her outright,
all marital.
that's marital.
Right.
That's it. He's going to get it. Whereas if you leave it in trust and you could say, I want it to my daughter, and then this is the biggest question. I always know the answer to this question, but I ask it anyway. Say, hey, if your daughter were to die, would you want it going to your son-in-law or your grandkids? Always the grandkids. So we have a dynasty trust provision in there, and we have that in there. So there's a lot of reasons to use a trust. Avoiding probate is number one, but that have nothing to do with estate tax.
Right. I mean, that's interesting. I think people don't get that. Like, a lot
Yeah.
of people don't get that. I mean, as being a lawyer, I still don't. I call you all the time.
Yeah.
I tell you do like a quick here it is that. By the way, you and I need to sit down because there's been changes. So
Yeah.
I have to sit down. But let's move on to another section that I think is important that most people don't even understand, right? And the asset protection.
Sure.
How does that play into it? Did you have to have, with the trust, what's the difference? Who is your clients that you're looking for? Where are they? What condition usually are they in? Where does
Yeah.
it come up? That kind of thing.
So for asset protection, it's funny because one of the lines I always use when, just like you said, people are awkward talking about death. I always say the death rate is 100%.
100%.
Death rate's 100%. But I always say in Florida,
Batting 1,000.
Yeah, exactly.
It's batting 1,000.
But I always say if the death rate's 100% in Florida, the litigation rate is just under that,
Mm-hmm.
right? Everyone gets sued, and so we have to make sure you're protected well in advance of that. So with asset protection, almost everybody needs it if you have assets and you have threats. Sometimes people call up and the only thing they're scared of is like, oh, what if I get in a car accident and things like that? And there's valid, fear to that. But a lot of times with those people, there's easy solutions. Maybe a simple LLC for assets that
Right.
aren't already protected. But if they have, retirement accounts and homestead, those are already protected. So the people that need me the most are business owners. Business owners, if you become successful enough, you're going to get sued. You can get sued by an employee. You can get sued by a client. You can get sued by a colleague or a competitor. There's going to be some type of either a contractual dispute or a car crash. One of your guys crashed into someone with a vehicle owned by your company. There's going to be something that happened.
Right, but you're talking about when they're piercing the corporate veil, or?
Well, here's the thing. The
So
assets are-
just real quick, for viewers, when you're a corporation, usually you're protected personally from lawsuits. That's why I'm asking that. Unless they do what they call pierce the corporate veil, you do something that somehow drags you personally into it. That's why I'm asking that question.
Sure.
So just to kind of bring
So it depends on what it is. Like, so for instance, you and I own law firms.
Right.
Law firms are a little different. Like, my law firm's a corporation, like I said, but I'm drafting the documents. Like, any lawsuit against my law firm, I'm going to be in that anyway. There's
Right.
not a way. So what I have to do is shield my personal assets
Right.
from the liability of my business. So in my case, my asset protection is I want to take the cash, the brokerage accounts, the other investments, whether it be real estate or other businesses, and keep those far away from my law firm. Because my law firm I look at as not only an asset, but a liability. Sometimes, a lot of my clients that need this asset protection for their business, they are in businesses that are immediately litigious on their face.
Right.
So I have a lot of rehab centers, a lot of assisted living facilities, anything electrical, engineering, or generators. I have those. I have big companies with lots of employees. And what happens is they look at their entire company as an asset. And I point out how they're going to be sued. So I look at the structure and I say, so I have a very close friend that lives out in Dallas. And when he was doing his asset protection for his new company, which his company, and you'll hear what he does and you'll immediately say, yeah, that's a lawsuit waiting to happen, is he has a bunch of daycare centers throughout Texas that take care of high-need children. So that could be a child who has cancer or MS or any type of disease or just maybe they're just severely autistic, whatever it is. And what they do is they pick the kids up from home and bring them to the centers with buses.
Oh, wow.
So I'm thinking, all these different things that might happen with the nurses that are there and the teachers and the this and the that, anything could happen. Well, one of the things I saw immediately was I said, how are the buses owned? And he said, they're all owned by the same company. I said, we're killing that right now.
Right.
So what we did was each piece of real estate is owned by a different LLC. The company, the operating company, is an LLC. Accounts receivable is an LLC. HR is an LLC. But most importantly with this case is we took all the buses and put them in their own LLC. And we created a leasing agreement. So the company leases the bus. The HR company leases the driver. Nothing's connected to the company itself. Well,
It's a nightmare for a litigator.
So what
Nightmare.
And
Like,
what
my litigating brain's going like, oh, you
Absolutely. Take the insurance
like,
and
oh,
run.
you bastard.
Yeah, exactly.
Yeah,
You take the insurance and
yeah,
run.
right.
So and what happened was he had one of the bus drivers rear-ended a pregnant woman. She was pregnant with twins, sent
Oh,
her into
God.
early labor.
Oh, God.
He calls me up frantic. He said, what happened? I said, how are the buses owned? Like I said, yeah. So you're fine. And that's it. They couldn't do anything. They couldn't pierce through. So we separated the assets from the liabilities within the company. Now, he also is protected individually because of the way we set up the partnership at the top. Because it's a multiple member LLC at the top or a limited partnership, you can't sue the individual members. So even unless he pushed the kid in front of the bus, they can't sue him, even though he's the owner of the company. So a lot of times, with litigation, you include everybody.
Right, they just list everybody.
Exactly. So immediately he's like, I'm out. So those type of things are what we do. We look at a company, we tear it down to its basic bones, because most business owners, as you and I both know, you start a business and you go on GoDaddy and get your domain, and
Right.
you get your CPA and get your tax ID number.
Sunbiz.
And you go exactly. You go to Sunbiz and you get your name, and then what do? You go in like the game show contestant in the tube full of money flying around, and you just grab money randomly,
That's
and
what
you
it
come
is.
out and you go, I'm in the black. This is
Right,
great.
right.
And you're in the black, and you're in the black, and you're black. And then 10 years later, you've got a $20 million business. And then I ask easy questions like, hey, you guys have a partnership agreement? You have a buy-sell agreement? You have an operating agreement?
It
Prenup,
makes
postnup?
you nauseous.
They have nothing.
Right.
They have an upside-down pyramid with no foundation.
Right.
One little lawsuit or even a dispute between partners, the whole thing tips over and you go broke. So that's what we do. We go in and we make sure that even the companies that are there, we get to them and build the foundation before they go broke.
Right.
If they start out with me at the beginning, it's even better. It's even easier. But most of the time, they come to me when they actually have built something.
Well, how about the guys that are about to get sued? They know they're about to get sued. That's a good time. But what if they've already been sued? Is there anything to do there?
There is. And so
And are we in shady territory now?
Well, here's what's great. So everyone talks about fraudulent conveyances, right?
Right.
Florida changed the Fraudulent Conveyance Act a few years ago.
Conveyance is a transfer of property or anything to somebody.
Exactly, yeah.
Right?
So when someone says, what they're trying to avoid is they're trying to avoid the situation of, oh crap, I just got sued, I have a judgment against me. Danny, take my money.
Right.
Just hold it.
Just hold on to it.
The issue with that is that's a fraudulent conveyance. 'Cause They
Right.
say, well, why'd you give Danny your money except to avoid the creditor? Makes no sense.
No, I owed him $17 million.
Exactly,
Like, right.
exactly. So what
Bad poker night.
Exactly.
Right.
So what they do, and this happens all the time, like, oh, why'd you give your brother the money? Reverse it. So they
He's
call
my brother. I love him.
Exactly.
But-
Well, they call it the Reversible Transfer Act now because it's not a case of fraud in that there's any penalty. The only thing they could do is reverse the actual transfer.
Got it.
So it's always a good idea to do something, but don't just give it to your brother or your friend. What you need to do is set up a structure that actually there's a reason for doing it. So I have a client. There's a real story from probably 8 years ago. Guy comes into my office with a judgment already of $20 million against him.
Oof.
And he's being sued by a major law firm in Fort Lauderdale. So I tell him, I say, listen, how old were your kids when you started your business, and how old are your kids now? So he says, my kids when I started the business were minors, now they're in their 20s. I said, okay, great. I said, do you have any estate planning done? He said, no. We created a full estate plan for the purpose of protecting him from estate taxes. And then by using the kids as the limited partners through irrevocable trusts.
They're erased from that judgment.
And what we needed to do
We're protected.
is,
Money can go to them.
And I signed an affidavit saying the whole thing, the whole reason for doing it, which is totally true, is at that time the estate tax exemption was very low. It was lower than now. It was $5 million. He was in excess of $5 million drastically. We were afraid of it dropping more, and we said we have to do this now. So everything we did was for estate planning purposes. The other side tried to pierce it, and the judge said...
Just saying you were doing it fraudulently.
Yeah, saying
right.
that we were doing it for asset protection
Right,
purposes.
Right.
The judge said that the Reversible Transfer Act, and this is right, has 3 tiers, 3-tier test.
Right.
Number 1 is, was there a judgment in place or an imminent judgment? So obviously in this case there was. Number 2 was, did the transfer of property make the person insolvent for the purpose of paying the judgment? And that's debatable because he still had control as the general partner.
Right.
But number 3 was there a legitimate reason for moving the assets from an unprotected to a protected place other than avoiding the creditor?
Well, there you're good.
And estate planning is the way to go. So
that's crazy.
Yeah. So and so what ended up happening now, I always tell clients, you're not getting off scot-free if you come to me with a judgment. So he did have to pay money. So from that $20 million judgment, he had to pay $650,000.
Wow.
Yeah. So he loves me. He refers everyone to me.
Are you kidding me? Yeah. I mean, most people refer everybody to you, by the
Yeah.
way. But that's great stuff. I mean, yeah, because it starts coming up a lot, you know, especially, you know, on the corporate side of our firm, we have people with value, a lot of value. I need asset protection. We're in the middle of litigation.
Yeah.
That's why, you know, it's good to have a working knowledge of what you can and can't do on that situation. Now, I have the last couple of minutes here. The ChatGPT. Do you think, people ask me, do you think that affects you? And I'm like, listen, I think it's a crazy tool we can use.
Yeah.
It's an impressive tool, but like nuanced, like it's like when people text me a legal question, I get so annoyed. Like I can't answer a legal question in a text. Like my answer is usually, well, it depends.
It always
if you did this, you did that. If you don't do this, you do that. And some things I don't even want to put in a text message. You know what I mean?
Yeah.
Talk to me about your business and ChatGPT and what you think the future holds there.
So I agree with you completely. I think it is a tool that can be used by us.
Right.
I think it can be used by us. I think that if you wanted to come up with ideas, like if you're brainstorming, it's good creativity. So if you say, hey, this is the scenario, what are some ideas? But then the lawyer has to go through and go, no, that would never work. That you have to know your client, you have to know your opponent in litigation,
situation, the
judge.
environment.
Yeah, there's a lot of things. There's no like experience is something you can't replicate.
But they call it the practice of law.
Exactly. We're continuously practicing.
Right.
You never perfect it. And with ChatGPT, I've even had, I'm sure you've heard the same thing, but maybe the listeners haven't yet, of the guy who tried to create his brief for his litigation on ChatGPT, and it came up with fake cases, and he didn't shepherdize them to see, and so he handed them to the judge, and the other side was like, we looked up these cases. They don't exist. They don't exist. So the problem with AI.
Like, what is Arkansas versus E-Man? Like, we've never heard of this case.
Exactly. and that's what happens. AI creates stuff. Like, so if you wanted, if for instance, if we said, hey, you know what, Danny and I are going to do a commercial. ChatGPT, give us some ideas of commercials we could do. It's good for it, because then it brainstorms a bunch, and we look through and we go, hey, this one's a funny idea.
I like that.
Like, I've even with my son created like rap songs. Like, hey, write me a rap song for Mother's Day. And it creates a, you know.
That's really cool.
It's fun like that, but it's for creative. It's not for actual legal.
Right.
Again, just like the guys who try to do it themselves on the LegalZoom or the willandtrust.com, which, by the way, Matthew Stafford is not doing his own will on willandtrust.com. He's worth hundreds of millions of dollars. He has a team of attorneys. But the key is, if you can get the ideas, and even, I don't even mind a client. I have one client, man. Every time, he's a corporate client, every time he comes in and he goes, here's what I got from ChatGPT. Is any of this legit? And I'm like, well, this is all garbage. This we can use maybe. You know, if you take it and then go to an attorney who, like you and I both, because we're specialists in our areas, when someone comes to me and says, man, I have the most unique situation. You're never going to be able to figure it out with asset protection. I'm like, I did it twice last Tuesday. You know, it's like, so I think that I'm not scared of ChatGPT, just like I wasn't scared when Costco started selling wills.
Exactly.
You know, those are not my client base.
Exactly.
But I think that if utilized, if harnessed, I think it can be a tool for us.
Agreed. Well, listen, I'm going to have you back on. It's always fun to have you, dude. I appreciate you coming on. And I think what would be interesting is, like, when you start to hear some of these celebrities, like the Matt Stafford thing, when you start hearing that, bringing you on and talking about it.
Oh, yeah.
You know, you'll cut right through some of this stuff, right? Like, you hear, especially in the media, stuff that you hear, and, you know, some of the horror stories about all these billionaires that lost all their money because they didn't do it the right way. I think that'd be interesting to bring you back.
Yeah.
I love having you on. I love you as a friend. I'll be in your office probably in the next couple of weeks, like I said. But thank you for coming on, Mike. You know, if you want to give a plug to your firm real quick before we go, and how to find you.
Sure. My pleasure to be here. Thanks for having me. And so our firm is WFP Law. So it's easy to find online, www.wf as in Frank, P as in Peter, law.com. So it's easy to go to the website. You can contact us by phone number, 954-944-2855, or via Instagram at Florida Law Firm.
Yeah, dude, always fun stuff. And he puts up little great videos that give you quick synopsises, too. But thank you for coming on, Mike. And to all my viewers and listeners, thank you for listening to Two Taps and Friends. Please like and subscribe to the channel. When you do that, it gives us more power and outreach, and it helps the channel out. And we love you, and we keep bringing you more stuff. You can follow us we're on YouTube, we're on iHeartMusic, we're on Spotify, we're on Apple Podcasts. We're literally everywhere. Also, there's a link at the bottom. You can buy Two Taps and Friends swag. There's some cool stuff there. Please like and subscribe again. Thank you so much for listening. Always enjoy bringing content to you guys. Love you all. See you next time. Cut.